Okay, so today's lesson is on voting rights, and the Louisiana literacy test I gave you was a real literacy test used to keep blacks and poor whites from voting, people who couldn't be trusted to vote properly, couldn't be trusted to vote for the people that the Democratic Party controlled things in those days that they wanted people to vote for. I want to start with Article 1, Section 4 of the Constitution. It sets out the basic rules, which are very simple. So the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at one time by law make or alter such regulations, except as to the places of choosing senators. So the states have the basic job of making the rules, but Congress can come along later and change those rules. And you'll see that's what Congress has done. The 15th Amendment to the United States Constitution was ratified in 1870, and it was meant to do away with discrimination, laws that discriminated against former slaves and denied them the right to vote. So it says, the language of the amendment says, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. But for about 100 years, many states effectively got around the 15th Amendment through literacy tests like the one that I just showed you. And so the Voting Rights Act of 1965 was necessary to give effect to the 15th Amendment, right, to make it effective in these southern states. So it establishes nationwide protections for voting rights, and one of the key provisions is in Section 2, which is a general provision that prohibits every state and local government from imposing any voting law that results in discrimination against racial or language minorities. It prohibits every state and local government from imposing any voting law that results in discrimination against racial or language minorities. And these are images of the Louisiana's literacy test. Notice on that test, it doesn't mention race. It doesn't mention previous condition of servitude. It doesn't mention color. It doesn't have to, because it's designed to target a specific group of people without ever mentioning who they are, right? And it was implemented in a biased way as well. So this is the kind of thing that the Voting Rights Act was meant to get rid of. This chart is very useful, I think, for showing you how effective the Voting Rights Act was. So on the left, you see black and white voter registration in 7 southern states before the Voting Rights Act. And then on the right, you see voter registration, black and white, after the Voting Rights Act. And first, look at the kind of orangish bars, and you can see the black registration just skyrockets. If you want to look at Mississippi, on the before March 8, 1965, it's less than 10%, right? So fewer than 10% of black Mississippians were registered to vote before 1965. But after the act became law, black registration in Mississippi goes up to about 60%. In just 2 years, right? So it just skyrockets. That's how effective the law was. And you could say this law changed American politics, American life, as much as any other law in that regard. It's also interesting to note, though, that white registration increased as well in most places. So, looking at an example, how about Alabama? In Alabama, before 1965, about 70% of white Alabamans are registered to vote. After 1965, it goes up to 90%. So the Voting Rights Act protected poor whites as well. It protected all people's right to vote. Now, there was a special provision of the Voting Rights Act that I want to explain a little bit. It was Section 5, and Section 5 had a pre-clearance requirement. And what this meant was states that were covered by this rule could not change their voting laws without getting pre-clearance from Washington first, from the federal government. They had to go to the U.S. Attorney General or to the United States District Court for the District of Columbia, and they had to get an okay, a thumbs up. And what the Attorney General was looking for was to make sure that any law that was going to be passed in Texas or in Mississippi wasn't going to harm black voters or registrants to vote. Another provision that came along a few years later, around 1975, required jurisdictions containing significant language minority populations to provide bilingual ballots and other election materials. I think I showed you all a picture of a bilingual ballot in Texas a few weeks ago. That's required by law, by the Voting Rights Act, as it was amended around 1975. Now, a little bit more about this coverage formula. So, the coverage formula decides who The coverage formula decides which states and which political entities have to get pre-clearance and which don't. Because not all states have to do it. New York, for example, never had to get pre-clearance. They can change their voting laws and they don't have to go to the Attorney General first. Now, they're not allowed to discriminate against people, but they don't have to get pre-clearance. So the formula was decided upon in Section 4B, and it had a rule. It said, any state or political subdivision of a state, like a county, that maintained a test or device restricting the opportunity to register and vote fell under this jurisdiction and had to get pre-clearance from now on. So in Louisiana, they had the literacy test. This was a test or device that was meant to prevent black people from voting and poor people. And therefore they fell under Section 4B, and they had to get pre-clearance from now on, right, forever, according to the Voting Rights Act. It didn't mean they couldn't pass their own laws. It just meant before it went into effect, the U.S. Attorney General had to inspect it and say, okay, it's good. There was a second element. If less than 50% of the persons of voting age were registered to vote in 1964 when they were writing the law, or less than 50% of persons of voting age actually voted in the presidential election of November 1964, then they were also going to fall under the pre-clearance. So if you had less than 50% registered or voting. According to these rules, the states that were initially covered by the Voting Rights Act were those 7 states I mentioned earlier, the southern states, Mississippi, Alabama, Georgia, South Carolina, and so on. In 1970, the act was revised slightly. They used 1968 as the benchmark for deciding who had a test or device, or who had under 50% registered or voting for presidential elections. And this added new states to the coverage. It added Alaska, Arizona, California. You don't need to memorize these. Alaska, Arizona, California, Connecticut, Idaho, Maine, Massachusetts, New Hampshire, New York, and Wyoming. I screwed up. They were added at least partially, not fully. Half of those states were able to bail out and not get covered, but the main idea here is the coverage widened. More states fell under the Voting Rights Act pre-clearance requirement in 1970. And then in 1975, you have more revisions to the law. Here, they added provisions to address voting discrimination against language minority groups. And this was defined as people who were American Indian, Asian American, Alaska Natives, or of Spanish heritage. They didn't really know what to call people of Spanish heritage yet. Sometimes this noise from outside bothering me. Sometimes they were called Hispanics. The word Latino wasn't really common yet, but Hispanic ended up being the one that the census settled on by the end of the 1970s. So Congress also expanded the coverage formula. So the presence of tests or devices or low levels of voter registration in 1972 would trigger the pre-clearance requirement. And there was a very interesting change to the definition of a test or device. It was expanded to include the practice of providing any election information, including ballots, only in English in states or subdivisions of a state where members of a single language minority constituted more than 5% of the citizens of voting age. To make sense of that, right? Texas never had a literacy test. Okay? Texas had poll taxes. You had to pay a tax to register to vote, and that kept poor people from voting, and that kept minorities from voting. But there was never a literacy test in Texas. So Texas didn't, in 1965, qualify for the pre-clearance requirement because there wasn't that trigger there. But they changed the requirement. Now they said, if more than 5% of the people in a county speak a language other than English, and you don't provide ballots and other election materials in that language, then you are using a test or a device to prevent those people from voting, and it triggers the pre-clearance, just like the literacy test did in Louisiana. So, in Texas, are there any counties where there are more than 5% of the people who speak a language other than English? Lots of them, right? Down in the Rio Grande, we've had probably majority Spanish speakers forever, right? Since as long as Texas existed. And so Texas obviously fails that new requirement, and Texas from 1975 on had to get pre-clearance. That means anytime we had a new voting law, the U.S. Attorney General had to approve of it first. But there was a very interesting case in 2013 that started in Texas, and it was called Shelby County versus Holder. Holder was the U.S. Attorney General. And I won't go into the details. Actually, Shelby County was from Alabama, I think, but I thought the case started in Texas. I might be confused, but either way. What happened was Shelby County wanted to change its voting requirements. The U.S. Attorney General, who was named Holder at the time, said no. Said this fails the pre-clearance, it discriminates against minorities. Shelby County appealed all the way up to the Supreme Court, and the Supreme Court struck down the coverage formula. That rule that said if you have a test or a device, or if under 50% were registered in 1964, or actually it had been updated to 1972, and I don't think it's been updated since then, but I may be wrong. The Supreme Court said this mechanism, this coverage formula, was written over 50 years ago, and it just doesn't apply anymore. It just doesn't make sense anymore to make counties and states have a pre-clearance requirement for something they were doing 50 years in the past. So it struck down that. Now, it didn't strike down Section 5, but Section 5 is unenforceable without the pre-clearance requirement. Notice also, it doesn't strike down the rule that you can't discriminate against people and prevent them from voting. That's still illegal. So if Texas were to write a law designed to prevent blacks or Hispanics from voting, it would still be illegal. They just don't have to get pre-clearance from the Attorney General before the law can go into effect. And that brings up an interesting debate that occurred within the last 10 years or so over Texas's voting laws. And it started in 2011 when Texas enacted SB 14, Senate Bill 14. And Senate Bill 14 set up a photo identification requirement to vote in Texas, the strictest one in the country at the time. Maybe still the strictest, I don't know. So this requirement said that every voter must present one of the following at his or her polling place when he or she goes to vote. You don't need to memorize this list, okay? A Texas driver's license. In fact, I'll add a chart to this before I put it on, showing you the list. So if you get confused, you can just look at that chart. But a Texas driver's license, a Texas election identification certificate, a Texas personal identification card, a Texas concealed handgun license, a United States military identification card, a U.S. citizenship certificate, which has your photograph, and seventh, a United States passport. So all 7 of these items have photos on them. So they're issued from the government, either the state or federal government, so they satisfy the requirements of the law. And you had to have one of these in order to vote, according to this original law, SB 14. Now, this was in 2011, and Shelby County hadn't been decided yet, so Texas still had to get pre-clearance from the Attorney General before the law went into effect. The Attorney General said no. The Attorney General said this law would discriminate against minorities, making them get photo ID or show photo ID to vote. And Texas fought back in the courts, and it started about a 5-year process of legal battles in the courts. Actually more than that, several years. A 3-judge panel in the U.S. District Court for the District of Columbia sided against Texas in 2012, said that Texas's voter ID law would negatively impact minority voter turnout. And then in June 2017, Governor Abbott signed SB 5 into law, Senate Bill 5. This was an amendment of the earlier voter ID law. It added an affidavit option. So it said, if you don't have photo ID, you can sign an affidavit explaining why you couldn't get it, and then you could still vote. And you would have to show some other kind of ID, and it could be like a bill with your address printed on it, something like that, a backup form of ID. Well, a federal judge, her name was Nelva Gonzalez Ramos, issued an order barring implementation of Senate Bill 5. She said basically this was not good enough. It still discriminated against minorities. It didn't remedy the problem that the Attorney General had found 5 or 6 years earlier, 5 years earlier. In 2018, a 3-judge panel of the United States Court of Appeals for the Fifth Circuit reversed the district judge's ruling, which meant allowing the Texas law to go into effect. A few months later, the Fifth Circuit dismissed another appeal from the federal government, I think, or actually it was probably from private citizens. But there was a further appeal on June 19 of 2018 that the Fifth Circuit dismissed, and that finally allowed the Texas voter ID law to stand as it is today. So it was a battle that took about 7 years, right? From the initial passage of the voter ID law to finally winning the battle in the courts of appeals. Now this is just, I said Texas was the first and at the time the strictest, but Texas was not the only state, hasn't been the only state to enact some kind of voter ID. So right now, there are 35 states that enforce voter identification requirements. 21 of them, like Texas, require photo identification at the polling place, and the remainder accept some other form of identification. And what counts as valid ID differs from state to state. Usually it includes driver's licenses, military identification cards, state-issued identification cards, and so on. And there is a lively debate in Texas and around the country about whether or not these voter ID laws are constitutional. There are still many people who think they violate the Voter Rights Act of 1965 because they have the effect. In other words, the argument that people who don't like these voter ID laws make is they say it's kind of like that Louisiana literacy test. It doesn't say anything about race or nationality or language groups or poverty, but it has the effect, they say, of keeping poor people who tend to be minorities from voting. And so it violates the 1965 Act. So 3 common anti-voter ID arguments you hear, that they target minorities, that they are a burden for many voters because it takes expense and time to acquire the sufficient ID to vote. And then the third argument that is often made is that in-person voter fraud, which is what the voter ID laws are meant to prevent, is so rare that voter ID laws just aren't really necessary. It's not really a problem to begin with, so you don't need this kind of a solution. On the other side, you have supporters of voter ID laws, and obviously in Texas they won because we have a very strict, well, fairly strict voter ID law. They say requiring voter identification prevents fraud. They disagree with the argument that it decreases minority voter turnout, and both sides have studies that purport to show that they're right, the other side is wrong. People who like voter ID say that when they go into effect in places like Texas and Georgia, minority voting and registration doesn't go down, it's not affected, so that's just not an issue, according to them. And they also say that requiring identification to vote is not really burdensome. In many states, some form of identification to vote is provided for free for people who can't get a driver's license or passport for whatever reason. So that's the state of the debate, and that's where we'll stop for today.